many, many other types of forensic evaluations that I want to get through. Competency evaluations. Just a bit about what competency evaluations are. I know a couple of you said that you do them or have done them. Competency, 1994, the American Bar Association's Criminal Justice Mental Health Standards noted that the issue of present mental incompetence, quantifyingly speaking, is the single most important issue in criminal mental health field. The most recent estimates say that there are about 24,000, between 24,000 and 60,000 forensic evaluations of defendants that are going for competency to stand trial in the U.S. every year. So what it is really determination of competency, just specifically competency to stand trial. There are many types of competencies that are out there. Competency evaluations. Now, the competency stand trial evaluations are done in a state hospital, at Napa State Hospital, as one of our attendees. Everything you did. So you could talk to that in a second. But there are many other types of competency evaluations that some of you who are going into private practice might actually take on. Someone was talking about competency for the death penalty, to be executed. But there are other ones. There are to plead guilty, Miranda. There's competency to even be sentenced. Yeah. Competency to do a will, to actually execute a will. But there's also adult guardianship and conservatorship that kind of falls under. And then, of course, competency to make medical decisions. So going into private practice, you might be able to do any of these types of competency evaluations. And there are extra trainings out there for all of these. In fact, I've been to some CEs that are really excellent around competency to make medical decisions, specifically with regard to dementia and neuropsych assessments that we do. Two gentlemen I've done testing, not testing with, but just in-house evaluations for, who had become incredibly depressed after appeals that they had said they don't want had been honored. So these two guys were on death row. They were condemned. They had given up. They said, I want to be condemned status. It's fine. Execute me. I know when my day is. It's okay. And suddenly they were made into life without possibility of parole and got incredibly depressed because they went from living in the penthouse, which is what California or San Quentin calls it, specialized housing unit with a special yard and special privileges, to having a cellmate in a tiny little cell with no special yard and having to work. Yeah. These two guys, super depressed, one of them incredibly suicidal and had to be on suicide watch for a couple months. So, you know, I can understand the competency to refuse appeals would be out there as well. So competency to stand trial looks at the mental state at the time of trial. It means competency. Insanity is mental state at the time of the offense. So those are two things that you need to kind of differentiate in your minds. Competency includes being able to assist in your own defense, which I know that you're going to be talking about in a second. And the instruments used are the MCAT and the FIT, which is the Fitness Interview Test Revised. So competency stand trial, the inmate is interviewed over periods of days, sometimes weeks. Different kinds of testing is involved. They look for mental retardation, different forms of mental disorders, and any kind of organicity that would impair a person's ability to assist in their own defense. If a person is declared incompetent, the court will order them under civil commitment to undergo rehabilitation with drugs and whatnot until competency is restored. Oftentimes, people are sent to Napa State Hospital because of English as second language, cultural concerns. They don't understand the court, and so they go through mock trials and they are taught how to act in court and what each of the different people in court does, so that they can then help in their own defense. If the defendant is found incompetent to stand trial, no trial is held, but something else. at the state hospital, the individual stays at the state hospital until competency is restored. Sometimes that could be a few days, sometimes it can be a longer time. Oftentimes, I have been told by attorneys that competency is often used as a technique to buy time. So people will say, oh, my guy's in competent stand trial. They'll send him, they'll say, we need a couple of months. Pretend like you're crazy for a couple of months while I build my case. Suddenly they understand. So you have experienced that. I love having someone in the audience with experience. So yeah, it's a time buying technique for some people. And you have a number of different things. So the individual is either found to be, if someone's found to be malingering right off the bat, they're sent back to court. Competency, if it can't be restored, you found this person has such brain damage that they're never going to be able to assist in their own defense, and it's been about a year, they can be placed under conservatorship and sent to a group home. I believe in the state of California, if 3 years have passed and a person can't be, competency can't be restored, they are placed on conservatorship and then released to a group home. It's very interesting. I had a guy I was testing a few months ago, and he was competent, a little bit lower IQ, lots of drug use, but he said, oh yeah, in the 80s I was found incompetent to stand trial, and then I lived at the group home. You know, I was only in Napa for about a year, and then I was sent to the group home. I really fooled them. I thought that was particularly interesting. He wasn't fooling with me. He had some serious deficits. We were trying to figure out what was going on, but it was interesting that happened. So yes, there's a lot of different problems with competency to stand trial. Different people in the audience are talking about different things. It's on the one side we've got the ethical issue of parroting, just teaching someone, enough to appear. But then, if it's found on appeal that they were just taught to parrot back something where they're never actually competent to stand trial, it could be overturned. Yes. So that's the other side of things. And for those of you working in private practice, you might actually do a good practice overturning different things when someone's not competent. All right. So the two things that I was talking about, the two tools, the MacArthur, is a 22-item structured book that looks at understanding capacity for factual understanding of the legal system and adjudication process, reasoning ability to distinguish more relevant from less relevant factual information, and appreciating the capacity to understand his or her own legal situation. There's the MacArthur competency evaluation. There's also the MacArthur that just looks at other types of competency, like competency for medical decisions. So there's a couple of MacArthur competency tests out there. I think it's called MacArthur treatment that helps for decision making. The fitness interview test is also a structured interview designed to assess people's understanding of competency. But what about other competency evaluations? To plead guilty, to waive Miranda, whatnot. Competency to be sentenced it came about because of Chavez versus the United States. I really hate case law. I hate it with a passion. However, some of it's really interesting. And so if you actually read the cases behind it, it solidifies it in your noggin, and you're better to do on the test later on. Okay, so it was the landmark case for competency to be sentenced and participate intelligently in to the extent that participation is called for. So what happened with Chavez? Chavez was indicted by a grand jury on 3 counts of bank robbery in 1976 and appeared in court and said he wanted to represent himself. He then had an outburst, and the court required him to be removed. Over the course of the next few months, he was evaluated, but before those records were admitted, Chavez fired his attorney and pled guilty. In 1978, as he was serving his time, he filed a motion to vacate the sentence on the grounds that the trial court failed to order on its own motion a hearing of competency to plead guilty. So while he was being evaluated to be if he was competent to plead guilty, he failed his attorney and pled guilty anyway. They found him guilty, and then he pled that he was incompetent the whole time. The court, who had already ordered the competency evaluation, made the mistake of not getting that competency evaluation back. And lo and behold, this guy, it was found that he was deprived a civil right of effective assistance of counsel. So that's why we now have probably Napa State Hospital doing all these competency evaluations. Waive Miranda. Grisso outlines a whole bunch of information. Grisso also writes a really good book that's out there, and found that the functions for a person to be able to waive Miranda include understanding words and phrases of Miranda. So who in here knows the Miranda warning? I've practiced this in my head because I had this little fantasy that I might make a citizen's arrest someday. I don't know if anyone else watches Law & Order, but anyone know Miranda? So, and I didn't have these last two. So you have the, right to remain silent. If you give up that right, anything you say can and will be used against you in court of law.
Right to attorney.
You have the right to the attorney. That's right. If you can't afford an attorney, one will be appointed to you at no cost to you. And then it goes on. If you wish, you may decide at any time to exercise your right to remain silent or to give a statement. You may stop giving a statement at any time. All right. So to waive your right, to waive your right to Miranda, and to be competent to waive your right to Miranda, you need to understand the words and phrases of the Miranda warning, which can be read to in a number of different languages. And accurate perception of the intended purposes of Miranda rights, which include the person's understanding of the nature of interrogation, the perception of the attorney-client relationship, what does that mean, what will an attorney provide for me, and perception of the irrevocable protection from self-incrimination. So to be able to waive your right to Miranda, you need to be competent on all of those levels. And if you're not, you might be found that you're not competent to waive Miranda. So it's just something to keep in mind. All right, so there's also guardianships. And guardianships are really the legal mechanism by which the court delegates authority to someone to help them with their estate or person. It's possibly the most ancient aspect of the system, and mental health laws really kind of helping persons who aren't competent to take care of themselves. It goes back as far as Roman common law, and it's based on the duty to guard. That's where it comes from, guardianship. So guard the estate of incompetent people, for instance. So determining need for guardianship is left up to the courts, and there are many, many concerns with this. Because if guardianship, by the way, and conservator are often used interchangeably. So if someone is given a conservator, given a guardian, it's usually in these day and age to act as a payee for SSI or whatnot. And a lot of the research that is out there shows that this is an abused system. So someone is listed as a conservator, they take the checks and they don't give it to the person that needs it. And that's one of the biggest problems that's actually across all of the states. So failure the second biggest problem is failure by courts to track guardians. So once they've assigned a guardian or conservator, they don't track them, they don't keep track of them, and and then, of course, not monitoring them and what they do. So they might know you're the guardian, but they don't pay attention to what the person is doing. There's also the decision to, or decision-making, treatment decision-making, and medical. We actually do these type of competency evaluations in-house often. People who want to go on hunger strikes or don't want to take their medication anymore. And there's a lot of different things that go into that. The biggest one is understanding. So it's really broken down between understanding, reasoning, and making a choice. And first and foremost, disclosure. So what does this medication do? What does this treatment do? You've got gangrene in your leg. How are you going to take care of that? We've got a vignette that we're going to talk about in a minute. Has the client been given enough information to make the decision? Do they, in essence, have informed consent? Understanding goes really to the ability to comprehend the diagnosis and the treatment and any treatment-related information. And then you can test this by looking at their ability to attend, to encode, and then to store and retrieve that information. So if you've talked to your doctor and you've been given a whole list of things about what this medication does or what this treatment does, can they then tell you in their own words what that treatment does and what will happen if they don't have that treatment? So that goes to the understanding and appreciation. If they don't take that treatment, what might happen? They might ultimately die. Okay, well, as long as they're aware of that and they're not necessarily suicidal, or they could lose their leg if the leg isn't treated. They're diabetic and they have gangrene. Also, reasoning, which is really the processing ability to analyze the situation and make a competent choice. And then, are they actually able to make a choice? Are they able to communicate that decision about treatment? There's another thing to think about, voluntariness. Is the person voluntarily able to make treatment decisions? So I got a little vignette going because I figured I'd mix it up a little for you guys. 80-year-old man with type 2 diabetes admitted for a gangrenous ulcer on his left foot. His doctor wants to amputate the foot, but the patient declines, stating that he has lived long enough, he doesn't want to live without his mobility, the little time he has left. How should you, as the clinician, proceed? Because I have, how should the physician determine competency? But we'll assume that that physician said, I want a shrink on board, contacts you. What sort of things do you want to know?
His religion.
His religion? Why?
A lot of religions, they don't want to have any type of surgery like that because they don't want to have blood transfusions and stuff.
Excellent.
I want to make sure his general cognitive status and
Okay.
any dementing conditions or his IQ.
So you definitely want the mental status exam, and you can bring in some measures at this point. You can bring in the Cognostat, you can bring in the MMSE, which stands for the Mini Mental State Exam. Both of those can look at orientation, recall, short-term memory, that sort of thing. What else?
Make sure he's not clinically depressed, I guess.
Okay, so mental health factors. So we want to know if he's meeting his ADLs already, and IADLs, which stands for what? That's ADLs, activities of daily living. There's a new one called IADLs, which is instrumental activities of daily living. And in reports, and we're differentiating between the two. ADLs are really, can you take care of yourself? Can you shower, feed yourself minimally? IADLs are, can you make appointments? Can you take a bus or drive yourself to an appointment? Can you refill a prescription? So really anything having to do with an instrument. And if you're doing any type of SSI evaluations or functional assessments, you want to differentiate between the two. Because it's different for, depending on if someone's living in a group home where they've got minimal supervision versus increased supervision. So yeah, you want to know about all of these. You also want to know, going back, are they being coerced? What's going to happen to their estate after they're dead? Maybe they're being coerced into this. All right? So you want to know their understanding, which we've already talked a little bit about this, that this is a life-threatening situation. We also want to know everything that they know about this situation, about having the leg amputated. We also want to know what sort of things do they know about possible mobility, because he says, I don't want to live without my mobility. Well, what does he know about being mobile after losing a leg? Maybe he can get a prosthesis. Maybe he could get one of those wheeled chairs and, that goes 35 miles an hour and he can run over the dog with. Maybe he can have more fun that way. I don't know. But what does he know about that? We also want to know about his reasoning and his ability to make the choice. Is he able to competently make this choice? So there's a lot of different things involved.